Okay. Well, I want to thank everybody for coming and let everybody know the recorder's on. So, thank everybody for coming to this work session where we're going to try to figure out the history and title to this area and see what conclusions we can collectively reach and see if there's something here that may help us to move forward a little bit towards the resolution of our difficulties. And I'm glad Tom and Allison are here because whatever I think I know about history of this area, they know about 3 times more, as well as Jim Ralston, who's also related into the family and has been in this area. As I said to him earlier, for his whole life, and he said, not yet. And we have others who have lived in the area for many years, like the Pennies. They've been here for forever. They have a lot of knowledge about what happened back at that time. So.
Oh.
Yeah.
Wow. Living remotely.
Can we sit in these chairs?
Yeah, take a comfy one.
Sure.
Sit right there.
Sit right in one of the.
It's actually not too bad. It's pretty comfortable.
Okay.
Quick
Yep.
Karen's already throwing a bottle around.
We're all set. Want me sat on the bench?
Okay. Yeah.
Don't panic and get my hand on.
We've had Karen pull whatever records we have from the planning office. And then the other thing that we have is up here on the screen. This is onto the online part of the New Hampshire, the Rockingham County Registry of Deeds, so that if we're referring to any particular instrument, we can put that up on the screen and anybody can read deeds as they are on record. So with this in mind, we will try to figure this out. The thing we have to start with when we look at how public roads are created, there is a statute, and also Peter is here and he can also tell me if I misspeak in any way. There's a statute, RSA 229-1, which goes through the various methods about how public highways are created. And there are 4 and only 4 methods of how public roads are created. If you haven't used one of those 4 methods, then you haven't accomplished it. There is one exception to that. There is a case called Hirsch versus Plonsky from 2007, where the Supreme Court said, if you have an area that is apparently a public way and a municipality has treated it like it's a public way, then at that point you may be deemed to have accepted it and not gone through the full and precise statutory niceties.
Question.
Yes.
Leonard Schwab, Great Bay Drive West. Was that statute in exactly the same form in 1928 when that was laid out?
No.
What was the form of the statute in 1928?
Well, we could put it up there and show you, but essentially the change that the legislature made in 1968 was to say that you could no longer create a public way by prescription. Prescription is like adverse possession, meaning that the public used the area adversely without claim of right, adversely to the real owners. That existed up until 1968. So they said if you hadn't used it for the 20 years prior to 1968, we will no longer create public highways by prescription. However, you can create interests that are adjacent to highways by prescription since that time, such as drainage easements, the ability to put utilities, those sorts of things. Those can be created by prescription, but not the highway itself. And so I'm going a little bit from memory, so people correct me if I get it a little bit wrong. The first way that you can create a highway that was done many, many years ago was called a layout. And at that point, citizens came into the selectmen and asked for the selectmen to lay out a particular road in a particular location. And there was a public hearing, and the road was laid out in a certain location. Damages were paid to the landowner whose land was taken, and the road was created that way. Okay. That was done many, many years ago because the damages that were paid to those particular landowners would have been very small. First of all, land wasn't worth very much back at those times. And secondly, people wanted roads to be laid out because if you can't get to your property, it isn't as valuable. So by having roads laid out to be used by the public, that was something of value. So today, we would call that eminent domain. If we were to go out and just lay out a public road in a certain location, we would have to pay damages, full fair market value to landowners when we do that. And so that's not a method that's preferred today. Second method is when it's on town-owned property. Third method was the prescription that we've talked about, which was like adverse possession. And the fourth one was called dedication and acceptance. Now, that's a two-step process, and that's what's key here. Dedication is when, on a modern subdivision, a landowner comes into a planning board and said, I would like to subdivide my land into the following lots, and I need it to be served by a road, and here's the road as I would lay it out, here's my subdivision plan. When that's accepted by the planning board and that plan gets recorded, that's the dedication part of it. And then you go build your subdivision, and at that point, you have to take the second step, which is coming back and having it accepted. Okay? If we take a recent road, like Van Etten, okay, that was laid out, that was dedicated by the subdivision plan probably, 3 years ago? It took about 3 years to build that one out. So the plan was recorded, and then it took 3 years for the houses to be fully built. And now the road has been constructed in accordance with that recorded plan. There was an acceptance that was created by the selectmen, but only after the planning board and the town engineer certified that the road was in fact what it was supposed to be. And that's when the acceptance happened. Now, there are a lot of plans that are out there where things get dedicated, and then years go by, whether it be because of a recession or whatever reason, and sometimes the acceptance gets delayed for a long period of time. That may have happened here. We'll find out as we go through all the records that we have. But I think it's pretty.
I have a question on that.
Yeah.
So,
Get you to state the name.
Oh, sure.
David Wallowitz. And is this being recorded?
Yes, it is.
Good. So you say it may have been. So there's a record of a 1993 town warrant that has been produced by the town.
A document.
So you question the validity of that document?
I don't understand it yet. It's part of what we need to go through and try to understand what it is.
It's a document. It came from the town of Greenland. It says on it that it's a warrant article. So let me see if I understand this correctly. You're actually contesting the validity of the document that you produced.
I'm trying not to create any conclusions yet till we all go through
I'm not
it.
asking for a conclusion. I'm saying there's a warrant article. It says that it's asked for a vote of the town on 20-something roads. And then there's another document that says it was accepted by the selectmen. I assume you don't accept that document either, but for purposes of continuing the discussion, you guys produced it. That's what it says. What's missing is the rest of what you just described, which is the approval by the planning board. Is that a fair statement?
Probably. We'll go through and we'll figure
So
that out.
I would like to clarify one thing. When you say you guys, all right, we're a different select board than what happened back then.
Oh, I agree with that. And in fact, let me say that after 1993, the town records show and state that Dick Rugg, and I don't know who Jay Weeks was, but I'm assuming.
That would be John Weeks.
Is he an officer or?
He was the selectman, yep.
They say, the town record says that they said that this was, our roads were town roads. And I can only tell you this much. I inquired whether our roads were town roads when I moved in, and I was told that they were, and our road was paved by the town, not only plowed, but paved, after I moved in. I moved in '96. So I guess what I'm asking is, why are we having the discussion about whether it was accepted in the missing records when you yourself have repeatedly said on the record, and you said in 2005, that municipal estoppel would apply if there were records?
Even if that's so, I need to know what it is.
there's a, even if that's so, Paul. You wrote an article on this.
Mhm.
The article says that if a resident, a taxpayer of a town reasonably relies on a representation of the town, and it turns out that the representation of the town was mistaken, that the town can't enforce that against the residents. So let me ask you another question. When did you personally learn of the 1993 acceptance?
Personally, when you guys brought it forward, I had not done a complete and exhaustive search of
So-
town records myself.
So that was never brought to your attention before we brought it forward?
Not to my attention. But anyway,
Wait,
David,
no.
but no, let's just say, let's suppose for a moment that you're
Who's
correct.
it then? So who
Let's
else?
suppose for a moment that you're correct. Is it 15 feet wide, 18 feet
No,
wide, 30 feet wide,
no,
50
wait
feet
a
wide?
minute.
I just don't know.
No, Paul, that's a conflation that you've been doing since 2005, so let's get this much straight.
It isn't conflated at all because I don't know what it is.
I'll tell you what it is.
Fine.
Okay, it is the road which the town of Greenland owns.
Okay. Are you saying that we have to own it in fee?
No, you own it. I'm not saying you have to, you do own it. You're not denying you own the road, right? Or at least the road that the brackets deeded to you.
We have a deed for something that is 18 feet wide.
So that's a yes.
Yes.
Okay, so that's the it.
No, that's important because the right-of-way could be substantially different than 18 feet in width.
I'm not talking about the right of way. You're the one who raised the right of way. I'm talking about the road.
We have to talk about the right-of-way.
We don't have, you conflate the two. The right of way is an issue later. The issue first, before you get to right of way, is who owns the road and is it a town road or not? You clearly own the road. Now, you cannot deny you own the road.
A Board of Selectmen did accept a deed for 18 feet
So
in
that's
width.
a yes, you own the road. Now, all I'm saying is that road was accepted. That road, was accepted in 1993. And since 1993, that road has been a town road that we have been told it has been a town road. We have relied on it. And I want to know why municipal estoppel doesn't apply.
Well, estoppel as to what?
As to your assertion that it wasn't properly approved, vetted, and went through all that stuff that you just talked about a minute ago.
Well, remember, the deed was 2015.
It's not about the deed, I'm talking about.
You just told me that it was.
The deed was it. You want to know what the it is that I'm talking about. I'm telling you the it I'm talking about is the road. That's the road. Now, I want to know.
May I suggest to you that the 1993 it and an 18-foot wide parcel of land owned in fee by the town may be two different things?
I don't care. My point is.
Well, you
we
should
live in
care because I
1990
can't fix something 18 feet wide.
You don't have to fix anything, Paul.
Well, thank you. But I guess I can go home.
No, you can actually, as far as I'm concerned, you could go home. But I guess my other question is this. You have a letter that you said you didn't know about the 93 acceptance until we produced it. So let me ask you this. When did you know about the January 3rd letter from Peter Laughlin?
January 3rd of what year?
This year.
When we reviewed it, right after January 3rd.
Why didn't you produce it to the people who it was written about, the people who live on the road?
Because it was an attorney-client privileged communication until it was released by the board.
It's not, well, I guess I want to know why it's an attorney-client privilege when you guys, and now I am talking about all of you guys, got a legal opinion that the road is likely to be a town road, and that if you were to go to litigation, there's a possibility that you will be held in bad faith. Why you wouldn't tell us about that?
Okay, now let's talk about conflation. Are you suggesting that we receive an opinion from an attorney that is not a privileged communication?
Yes.
Thank you. So it's privileged until it's released.
So why didn't you release it? Why did you wait to release it until I filed a right-to-know request?
Actually, I don't know if the board ever did, specifically work to release it, but it was released by our administrator under a right-to-know request.
So let me ask you this. I'll ask the rest of the selectmen this. Do you understand that if you force us to sue you, we will have to sue in good faith because there's now, sue you claiming that there's bad faith? Because there's a letter from your counsel saying that you may be held in bad faith. And if we were to succeed, you personally would owe your town's lawyer's fees. Your insurance company would not cover you, and we would ask for our attorney's fees to be paid. And the question would be, besides your personal potential liability, the question would be, why wouldn't you listen to the advice of your attorney, who made a recommendation, who we now know didn't have the 93 acceptance when he wrote the letter, which means that I think that the opinion would even be stronger in our favor. And the question is, when we asked about that, we were told that you guys are no longer using Peter as your attorney, and you're going to use our taxpayer money to hire another attorney? Why would you do that? You could use that money to build the apron or whatever it is that the Brackets need and want to do the right-of-way that he keeps talking about. The fact is really simple. And let me also say this too. You were asked at the last meeting, I think Mr. Hayden asked the question, but I couldn't tell because I wasn't here. And I don't know voices that well. Is the town liable if an accident occurs on that road? Well, I will tell you, the answer is yes, at least on our part of the road, because you own it. And there are kids who go down that, we have little kids now in the neighborhood, and they go down that road on their tricycles and their scooters down, and the potholes are worse than ever. I don't know that you're insured for that road, because think of it. You claim it's not a town road, and your insurance is municipal insurance, and municipal insurance covers town roads. So you put yourself potentially in a position that you own a road for which you're uninsured, you're about to buy litigation for which you're possibly uninsured, you've been given multiple legal opinions which you're not following. And I guess it's inconceivable to me that you would put yourself at this kind of legal risk. I have to say, I don't understand it.
Let me respond to that, okay? I'm not an attorney. And what goes on between attorneys, sometimes you guys kind of lose us, all right? When that document came from Peter, in my opinion, that was not a hidden document. It was brought out at the meeting, all right? It wasn't expounded upon, but it was brought out at the meeting. So it's public record, okay? I requested that this document be forwarded to the planning board so that they were aware of what was going on also, okay? Nothing is trying to be hidden here.
Point of order on that point.
Excuse me?
A point of order on that point about the
Now,
planning board.
wait, please, Mr. Schwab, will you please let him finish?
All right, I'd like to come back to that, please.
I'll be glad to recognize your question.
So, number one, I want to say that nothing is hidden here. My objective as a selectman is to do what the town meeting tells me to do, whether I agree with it or whether I don't. Honestly, I can tell you personally, I did not vote during that meeting to buy Great Bay Drive East and West. It was my understanding that when all of you people bought your properties, that was in your deed that was a private road. Maybe I'm wrong on that, but anyway, that was my understanding. Anyway, that's neither here nor there. In my opinion, all right, the last town meeting that I attended, and I wasn't a selectman at that time, the town meeting said that they would accept Great Bay Drive East and West, all right, contingent upon two things, that the deeds were turned over to the town, all right, and that the planning board approved it. Now, during my tenure as selectman, I'd forgotten about the planning board approving it. And I was willing to go right ahead and say, okay, this is the way it's going to be, all right? Because that to me is my job, whether I agree with it or not. But then it was brought to me at the last meeting that the planning board has to approve this. And I realized that Allison and Tom were here, and Allison got upset with me, but I have to do what the town meeting tells me to do. You know, and as far as I'm concerned, if the town meeting tells me, and this is what I've read all my life, tells me to do something as a selectman, I'm going to do it. If that's going to be overturned, it's got to be done by a court, or it's got to be done by another town meeting.
It already was done, though. It was already done.
Done when?
1993.
Well,
Right, that.
this is the problem with having a board of selectmen that is turned over and over and over and over again.
Excuse
Things
me,
get
could
lost in the
you
muddle.
introduce
you know?
yourselves too, because we're not familiar with you.
Okay.
Actually, but put the name tags up so they don't
Yeah.
throw things at you.
Yeah. My name is Vaughn Morgan,
Okay.
okay?
The five of us here are the current Board of Selectmen. I'm Paul Sanderson, Chester,
Justin Duraki.
Vaughn,
So anyway, expanding upon what
Jim Ralston, and Chip Hussey.
Thank you.
going on with what I was saying is that I want this problem resolved, all right? I want it resolved in the best interest of the town, not in your best interest or your best interest or your best interest, but the best interest of the town. So I am obliged to do what the town meeting tells me to do. And the only thing I can recollect, and believe me, I know this goes back centuries, probably, but I'm trying to get this thing resolved so I don't pass this mess on after my term is gone to the next Board of Selectmen. I want it resolved, and I want it resolved legally and amicably, because I'm not your enemy. Believe me.
I accept that, but if that's the case, why aren't you following the advice of your town attorney?
Okay, David, based upon that, what do you think we should be doing that we are not doing?
Well, the simple solution, which Peter didn't know about previously, one is if you follow his advice, he lays out what to do. But I would say there's actually a simpler solution, which is that now that you know that there's a 93 warrant article, that it was accepted by the Board of Selectmen, and that by the concept of municipal estoppel, which Paul so elegantly wrote a article on, that you cannot, the absence of any acceptance is something that doesn't prevent you from acting. I would just treat this as if you've now discovered records that make you realize that a mistake was made in 2005, and that this has all along since 1993 been a town road. Then that makes it a road. That makes it the road that's deeded a town road. Then you go to the next issue, which I don't have a brilliant solution to, but that's the next issue is how do you fix the road? We know you own the road, but if it becomes a town road, it doesn't solve the problem. You still have to fix it. My suggestion is that you use Peter's excellent services to work it out with the brackets. And my understanding from the brackets is that they just don't want their land in any worse or better position than it is currently, and they are happy to have the road fixed. I'm not going to speak for them, but that's my understanding, and they want to have access to their land, which is to me perfectly reasonable. And I've heard representations that they want paved driveways, which I do not believe is the case. But they should have an absolute right to access their road. But I would keep the two solutions separate. The first issue is it or isn't it a town road? I'd solve that problem first. And I do agree with you very much that you have an obligation to do what's in the best interest of the town. And I'm not asking you to do what's in the best interest of me. I'm sort of stunned that you're marching down the path of doing what's in the worst interest for yourselves personally. I would not, I would advise you all to get personal, private counsel on your decision to hire a new attorney and not follow the advice of counsel after he's put you on notice of the potential of bad faith. But that aside, the best interest of the town, in my opinion, is in what Peter's letter says, the January 3rd letter. And I'm mystified why you guys are seeking other legal opinions. There's nobody who knows more than he knows about the road.
Okay, Chip, can you tell us what the town voted in 1993?
Well, what they voted on was a motion by Don Ladd, shows you how old I am, I know who these people are, it's only initials. Second by Luther Preston, that the Selectman, Road Agent, Planning Board Chairman be authorized to accept town roads, any road completing during year and deeded to the town. Approved by the Selectman, Road Agent, Planning Board Chairman, and recorded by the town clerk.
That was the warrant article.
That was the actual warrant article
Yeah.
voted on.
Right.
Okay, now, David, that is a warrant article that's a standard in many towns.
Yep.
And that gives authority under 674-40 and 40-A for entities other than the town meeting itself to accept a town road. Okay, so that provided authority. Now, do we have the second part, which is some records suggesting that those entities, the planning board and the selectmen working together in accordance with that authority, actually accepted this?
We have one part of that. You have the vote of the selectmen to unanimously accept the 26 listed roads. You have that.
Yeah.
You do not have the planning board part because, from what I understand, they don't exist. And what I'm saying is that under municipal estoppel, which you've written about, that we do have records that Mr. Rugg and Mr. Weeks, they're in the minutes, say that they believe that they were town roads. Obviously, that would indicate that they believe they were town roads because of the 93 acceptance. I will also tell you that it's my understanding that that those roads, 20 some odd roads, were accepted and in fact solicited by Mr. Rugg because he wanted to expand the funds that were taken from the state. And I will tell you this, that in 2005, sometime after 2005, when your predecessor board tried to, and did rescind the status of our road, I put the town on notice that I believe that the town had a legal obligation if it was going to say that from all those years that it was mistakenly a town road, that it had an obligation to do an audit and determine how much they got in state funds and return those funds. And I actually had a conversation with Peter Laughlin about it, and Peter made the point that the amount of money was de minimis, meaning too small to matter. My response was, well, when I was a public defender, my clients shoplifted, and I argued that the amount was too little. It didn't stop the judge from finding them to have done something wrong. I've now subsequently asked, have you, since 2005, accepted state or federal funds for either east or west? I think that there's a possibility that you accepted it for east when you got FEMA money for east on the basis, and I'm not saying you did. Don't misunderstand what I'm saying. I'm just saying there's a possibility. Do you really want, this is what I'm saying to you, if I'm right on any of those counts, if I'm proven correct, if the facts prove that to be the case, that is powerful evidence of bad faith on the part of the town. Do you really want to go down this path when your own lawyer has written you a letter questioning good faith, which means that you individually could be on the hook for thousands of dollars and in violation of by the way, of your oath of office and all of that? And I'm not accusing you of that. Don't misread what I'm saying. I'm just commenting on if I were on a board and I got that kind of a letter from an attorney, I would follow the advice of the letter. I wouldn't go, why would you want to spend, and I got an email from Paul saying you're hiring another attorney. I don't want you to spend our money, the money of the people in this room, to hire another attorney. I want you to follow your lawyer's advice, and the money that you save, you can put toward a solution, whatever that solution of how the road can be rebuilt. But to buy a lawsuit, which is essentially what you're doing, if you continue to go down this path, is extraordinary. And I'm the first to admit that there is not a record that says that process that needed to be followed was completed. But I'm relying on Paul Sanderson's article, which I've educated myself on municipal estoppel, and his article starts out and says that the whole purpose of municipal estoppel is to make sure that residents and taxpayers of the town are treated fairly by the town. And if they reasonably rely on the representations of the town officials previously, and then it turns out that those representations were mistaken, the subsequent town officials can't enforce the correct interpretation against us. They have to accept the prior interpretation. Now, we can go to court and fight this. He'll be our number one witness. He'll be our number two witness. We're going to have to be forced to go for bad faith, and we don't want to do it. None of us want to do this.
I'm sorry, I must have missed that selectmen meeting, but as far as I know, we haven't told Peter to stop negotiating with the brackets.
You have told, I have an email that says that you will no longer be using Peter, you will be hiring new counsel.
What that email said was we weren't going to be using him as litigation counsel.
Yeah.
Which is a slightly.
But I
different
think, my personal opinion is Peter should still keep negotiating brackets to become, I think he's probably the best one to handle this and get it done.
Okay, now, David, thank you. You very cogently put together that argument. And so if we were to accept your premise that there is a town road there, because if for nothing else, we own an 18-foot strip of land.
Yes.
You now know that we also went out to Underwood Engineering to try to get some sort of an engineered response there as to what was the right thing to do to bring that up to good standard. Okay. You also know, by looking at that plan, that there are certain areas where contemplated improvements cannot be constructed within the 18-foot area. Okay. As part of that, we went to some of the other landowners, and they have graciously given us temporary construction easements, as I understand it, so that those improvements could be constructed. And we were in the process of doing that with brackets, but we had not yet been successful. And so what we were trying to do at this point was figure, what do we have here? Do we have in any way, under any argument, more than that 18 feet that has been deeded to us by some method or other that would allow us to do these construction improvements and get this road up to snuff?
Well, I appreciate what you just said, and I think, and I give you full credit for trying to resolve that issue. But you can't build a road if you don't have a town road. If you can't do it, you're acting like private landowners. So you gotta solve the first issue, that it's a town road. The second issue, I have every reason to believe there's nothing that, I hate talking about people when I'm sitting next to them. There's nothing that I have heard or seen that would suggest that the brackets are acting in bad faith. Quite the contrary. I saw the deed. It didn't seem that I think they gave the road to the town for free. I may be wrong, but maybe I missed something. And I've heard all sorts of representations through various people, like paved driveways and stuff. But I talked with Allison Brackett, and I didn't hear anything about a paved driveway. All I've heard was that they want access to their land. Then the only other question is, and if there's an issue, if they want to be sure that their land isn't damaged, then just insure against damage. I mean, you buy insurance for that purpose, or have Underwood. Not Underwood wouldn't do it. It's whoever your construction company is, have them buy insurance. And make sure that the brackets are made whole so that there's no damage to their land, which by the way, I would want the easement, whatever, no matter how wide or narrow that easement is. I took a measuring tape and I think it goes right to my garage door. So, I mean, we would want the same thing. We wouldn't want our land damaged. And I think it pretty much takes out all the landscaping, includes all the landscaping of the Schwabs. So I don't know, I do not have a solution for that, other than that I thought Peter was doing an excellent job, and I think you should continue to use Peter to do that. But I still say that this is made all the more complicated because you're mixing the two issues. The road, even if the road can't be improved, even if the road becomes a dirt road, I think it's a town road.
Okay. Well, is it fair to say on behalf of the board that we would like to construct the engineered improvements on Great Bay West?
Yes. I would definitely say so, yeah.
Yes. That would be a 5 for 5. We would like to see this done. We would like to see this issue resolved. We know from our discussions with Underwood, we simply cannot do those improvements, A, until we have a permit from DES, and B, based upon the permit that we have from DES, have enough room to physically construct the improvements as they're ultimately approved.
I accept that, but you didn't ask the question of your fellow selectmen whether they agree that the road is a town road. You asked them whether they want to approve it, but you make it sound as if it only if it's that the improvement is the only issue. There's another issue.
Peter, can I ask you a question? Can you definitively say that that is a town road?
I think it is. In my opinion, it
Think
is.
doesn't,
In my-
you see, think doesn't do it though.
I would say yes, it is.
You
And let me
definitely,
say this though, and Paul and I have been doing road law for
I know you.
40 years.
Yeah.
Paul edited the handbook used by every town in the state, a hard road to travel. For several different years he did it. I've done some writing on road law. And this is the most complicated road I've ever dealt with.
Okay, I just want you to hear that. And
So,
if it's complicated for him, believe me, it's complicated for laymen like us too.
I
We
think,
want to do the right thing.
I think there's an answer. I think there's an answer, but there is so many misfires along the way, and it's just not a simple thing. I think the solution is simple enough, but, and I think and there was discussion about whether the town owns the road and whether the town vote whether it was ever accepted. And that, when I used to work in Portsmouth, people used to say, well, there's no vote that such and such a road was accepted. And I don't know how many roads there are in Portsmouth, but probably 10% there was ever a vote to accept. They evolved, maybe by prescription or the other ways Paul talked about, but they became town roads. And so you can get hung up on, well, was it accepted? Is it a town road? 95% of the roads in the state of New Hampshire, the town does not own the road. And that's counterintuitive to what most all of us thought forever. The towns generally have a right-of-way. Paul talked about layouts, that the town would have in the 19th century done a lot of, and 18th century done a lot of layouts, and they sometimes paid damages, but all they got was a right-of-way. They didn't own the fee. It's kind of, doesn't make an awful lot of difference, but it's just not the way we normally think of it. So whether the town had a deed to this may or may not be critical. And there was disputes with Tom and Allison 15 years ago as to whether it was private or not. And Tom and Allison, at least Tom, I remember talking with Tom, felt that it was a private road, that they still had ownership interest. They had never deeded it. And so there's just one issue after another that makes this complicated. At the end of the day, I think it's an out-of-town road, and I think that the point that you talk about, which is you're absolutely right. The vote in 2010, which seems to me to be the critical vote, said voted to accept it, subject to. There were a lot of amendments. It was interesting when you looked at the different amendments and, well, we'll do this, we'll do that, and the final one was we vote to accept it, subject as is in its present condition, subject to approval by the planning board. And my understanding, the planning board never approved it, but if you look at it, there was really nothing for the planning board to do, because the planning board couldn't say, well, you got to bring it up to town standards, because town meeting already said you don't have to. And you're right, the normal, and Paul I think pointed out that normally, planning board has to accept it, has to be involved in it. The statute talks about the planning board being involved. But this is such an unusual situation that, and I can't point to a letter of the law that says that you don't have to have the planning board, but I think if you look at all of the equities involved over the last 50 years, that vote in 2010, and then the deeding by all the neighbors, and including especially the Brackets, I think puts it over the top that it's a town road and that the town has every right to maintain it. And I've had conversations as recently as today with Tom about the fact that there are places where you can't do the improvements within the 18 feet. If you're gonna do the culverts, you look on that plan that Underwood did, I think there were 5 wetland impact areas where you're gonna go more than 2 feet out from the pavement. And I think that the town has been, you know, wise, taking Underwood, forgetting his first name,
Phil McDonald.
Phil, yeah.
his recommendation that there be a construction easement, and there was a discussion about, and the way it was worded, it looked like the town was looking for a construction easement on more than 8 feet, or 8 feet in the town, and that, I think we're in the process of narrowing that down. The town really doesn't want a maintenance easement except on those embankments and around the culverts, and I think that can be worked out. And so you know, we can talk all night about, you know, who should have done what or whatever, but I think the solution is very close at hand, that we're gonna, I feel we're gonna have the clarification with the brackets to be able to do the construction that Underwood said should be done, and hopefully resolve this after a half century.
So in your opinion, taking into consideration the town meeting that said that we would accept the roads conditionally, those 2 conditions, one of the conditions has not been met so far. What do you think what is our recourse?
I guess you could go to the planning board and ask them to vote on it and tell them that there's nothing, they can't turn it down. I know board likes to be told that, but I think that condition is surplusage, that it really added nothing to, I mean, somebody at the floor town meeting was trying to get word an article on the fly, and, well, yeah, normally these things are accepted by town meeting, or go to the town meeting. I think the town meeting, go to the planning board, I think the town meeting had the authority. I don't think it was necessary, I don't think it really.
No, I know that, but it did. The fact of the matter is it did do that. So you're saying that our solution to this problem is for the selectmen to go to the planning board and say, look, we think you ought to, you know, give your sign of approval?
Or if you feel that selectmen feel that is necessary. I don't think it is. I think the selectmen would say, you know, given everything involved here, that isn't necessary. And I know that's troublesome because that's not what the town meeting vote said, but it's, it causes it's asking a board to do something.
Being down to another board.
Yeah.
Right.
Well, perhaps I misunderstood, but you did, I thought you said that the motion that was brought forth accepted it as is, and that would preclude the planning board being able to do anything anyway, is that correct?
Yes.
Okay.
And for the record, I would like to say that since the 1970s, when I was president of the Great Bay Homeowners Association, I felt that the town had the road, that it was, the town had accepted it, contrary to what other people may have told me. But in myself, that's what I felt. And when we heard from you in your letter, that just instilled to me even more that if it goes to court, we would probably lose. And I have been voting, as have my fellow board members, to get this thing fixed, and fixed right. So I just hope that it's done quickly, and the DES comes back with no heartburn for us, but that we can get this thing resolved, because to me, it's just common sense to get this thing done. We've got people down there that pay big taxes, and they've been putting up with back and forth and unknown entities here for too long.
Okay. So if we were to summarize, it would seem the thing to do would be to recognize the Great Bay East and West, both, because the deed covered both east and west, should be regarded as accepted as is to an 18-foot width. Okay? And that on west at least, what we should be doing is working with the abutting landowners where necessary to obtain temporary construction easements for repair.
Yes.
Okay.
I'd like to say something. When this all started back in,
Tom Brackett.
Tom Brackett, not a bad guy.
But the minutes of done by a recorder, that's not clear. Just needs to have a name to a voice.
We went around Great Bay Drive East and West, did some measuring of the roads, and then we added, some of them were like 12, 14 feet wide. And so we just added some footage, we figured you need it. And you guys are blessed to have Peter. We've talked to him 4 times over the last 2 weeks. We've met with the engineer twice. We have every confidence that this is going to be resolved. We signed some documents back in 2015, November. If you need some more things, just
The
what we're gonna
temporary
do.
easement for doing the work, that's
Okay,
what we need.
can I just, can I interrupt for just a second, Allison Brackett? That's the word, temporary easement. Yeah, but that's not what I keep getting as paperwork. What I keep getting is easement in perpetuity. Easement in perpetuity is not the same as a temporary construction easement.
Right, and I think
So
they.
that, I will
Right.
say, if somebody says, what's the holdup? That's the major holdup as far as we are concerned. The second holdup is, David is correct, we have not asked for driveways. What we have asked is, having done the walk with Phil McDonald, at some points, this road is going up 2 feet. If I have the right to access my land, and my husband, and our children, if I take a truck in there and then try to come out of it, and I damage the town road, I can bet bottom dollar you guys will come after me to fix it. I want a way to get in there that will not damage the town road on
So,
both
is
sides.
it safe to say a gravel ramp is what you're thinking?
Yes, that's exactly what I asked Phil for. So it doesn't have to be tarred. It would be to your benefit to have a few inches of tar, and Phil and I talked about this, to lead to the gravel ramp, because that is construction practices.
The other thing that, we walked with Phil and we just said, look, this has got to be safe. And if you need to tag any tree that you feel is necessary, if you got a fire engine and the police are going down there, so that they can see around the corner. See, neighbors probably saw a lot of tags on stuff.
We've had accidents.
The only thing I don't, you take the trees down, you're gonna take the brush, the wood, the stump, it's just gonna be a memory. I don't want a bunch of junk lying around.
We
That's
have,
it.
we have had accidents, you may not know about it because they don't all come back to the selectmen, where people can't see around that sharp corner. And because it's such a narrow road, there, unless you slow down and you take the corner in the widest way, if somebody's coming and doesn't see you, you could hit them. And we've had that, it hasn't happened to me, but I've noticed it's happened to other people.
Oh, there may be a dead tree that's gonna fall over and God forbid somebody's got a medical emergency out there. And look, this is the time to do it. It doesn't benefit me, but I'm really trying to do some give the town permission to do tree pruning so that it will be safe for you guys. That's the big thing. It should be safe and accepted. And I don't want us to become known as some legal case, like people 20 years from now will say, well, I got a bracket, or I got a mulligan, you know? So we're gonna try very hard to avoid that.
Thank you.
Are you welcome, Dave?
Go ahead.
Yeah, Cheryl Strong. I just had a question back to a while ago when Dave was talking. Did you answer his question on, have you received state funds for Great Bay Drive East and West? Did you answer that question?
The FEMA funds we did receive for Great Bay Drive East when it was flooded, and every year from 2005 on, the board voted to declare it an emergency lane. FEMA saw the document that we had signed declaring it as an emergency lane and approved the work with full understanding that it was a private road declared as an emergency lane and that culvert had washed out. I was completely honest and open with them.
He assumed you were.
That's the only way I operate, unfortunately.
I will say that it was brought to the town's attention at that point in time that the road had been accepted in 93.
Right, but
Oh,
And
oh,
I'll be honest that when I started in 2005, Tom came to me and said, I want you to work with the selectmen and make a deal. They've been wanting me to give them these two roads, and if you talk him into it, I want a piece of the town land and we'll do an exchange.
Well, the big
And that was
thing,
in
Karen-
2005,
the big
and the
thing, Karen, is
board
we were
said
putting
no.
together a package that the town could own the land. We were putting together a package for the town to buy the whole thing.
Right, but it
So
was
they could have
clear to me when
property,
you
and
offered
the-
to swap land,
and
that
the-
you still owned them.
And the road was gonna be transferred for $1 or something, because
But
that
it
was
was
something
right,
to
more
the
the other
advantage.
land.
Right, but that was 2005.
Well, I mean, I just
When we
didn't want
really
it to
had
be
transferred
thrown
in
into my
93,
face.
right.
But
That
it
I was
already-
trying to make money on some road that I don't care about. The only time I haven't claimed real ownership of that road was 1967. I was 14 years old, I was riding around on a motorcycle. One of the neighbors came out and said, we're gonna have the cops on you. And I said, my dad owns this road. So piss off.
But back then, when you
That was it.
back then when you were 14, you
Well-
were an adult.
I was also unlicensed, I didn't have a helmet, I wasn't registered, I know the statute, Ron.
Right.
But my dad said, we don't own that road, and we don't want to own that road. Period. So if you need me to sign another quitclaim, you can have it.
No, we have the quitclaim.
Good, it's a good quitclaim, right? Peter drew it
Yes,
up.
but we do need to have, I think, Peter's help to agree on the language of the temporary construction easements. And the only thing I would delay on now is to wait for the DES permit so that you can draft them in accordance with the DES
We
permit.
need that, unfortunately, we need the easement for the wetlands to give us the permit.
Okay,
They're holding up the permit, not for Willowbrook. Willowbrook, we got all the easements, and this is the only easement we haven't
then
got.
I would certainly ask that you work with Phil so that the language of the temporary
Yes.
easement is sufficient.
Right, the only perpetual part was, we had put in, I had talked with Attorney Laughlin, perpetually, that we could keep cleaning those culverts.
Of course.
Okay, the other
That's the
thing,
only part that says perpetual. and
but that isn't the
we'll
way it's
clean it.
worded. And so we have
No,
to get that.
it's, we got.
We're working
Well,
on that.
so, now, can we
Right.
choose the restaurant?
What restaurant?
The other issue,
I don't do that.
as part of that, I would like to
I
know
go with Peter.
from the selectmen and perhaps Karen,
We'll pay for dinner.
okay,
Thank you.
that construction easement and the part that the town wants to have easements into has gone from 3 feet when we were here almost a year ago, to 5 feet in the fall, to 8 feet now. What's going on?
What happened?
I think what I tried to do, or maybe it wasn't precise enough, is try to refer to specifically to the construction drawings.
Okay.
And they don't always show all of the slopes, but the place where they show, I think it's a shaded or crosshatched where there are some embankments for the wetlands. And that was where I think the town really needs to have the ability to maintain those, because those are probably the more dangerous areas, and you probably don't want to maintain them, so. But I think we can straighten that out. You're right. It says in the first 3 paragraphs, it talks about an easement, et cetera, or ability to use it. And the 4th one is what I tried to change to say that it's permanent, that it's in perpetuity on the embankments and the culverts. But it should be clarified in the beginning that the first part is not in perpetuity.
Well, I have every faith between Phil McDonald, engineer, and Peter Laughlin, attorney, that this can be all worked out. Or we can just keep coming back every month and have like a little club or something in the Great Bay Drive West Club.
Question, based on what we've heard, Tom DeCosta, 20 Great Bay Drive East. Based on what I've heard earlier and on advice of council, would it be appropriate at this time for the board to vote to accept the road as a town road without the approval of the planning board?
I'll be glad to accept a motion from anyone.
Well, I would like to first ask Peter, is this a proper motion without considering what the town meeting said? Would this be a proper motion?
I'd probably qualify by saying, under the circumstances and based on the facts discussed with town council, we make a motion, I mean, if that's what the board wants to do, we make a motion to accept this Great Bay Drive West as a town road.
I'll start it off. So move.
Second.
Okay, as Peter was finishing, Great Bay Drive East and West, as described in the deed from Tom and Allison Brackett in 2015, that entire 18-foot strip of Great Bay Drive East and West be accepted as a Greenland Town Road.
Okay. Now I'll ask.
So we've had
So move.
okay, if you accept that motion, it's been seconded. Motion by Selectman Huzzy, seconded by Selectman Ralston. All those in favor, say aye.
Aye.
Any opposed? Okay.
You know, and believe me, none of us, I really want you to know something. There's not a selectman I've ever served with that tries to act in bad faith in this town. We really work hard. I know you don't, you think we meet twice a month. We meet a lot more than that. We have different departments that we have to work with, and it ain't an easy job for 8 cents an hour. But we appreciate your coming and, you know, in this type of a forum, because this is what, usually we sit up in meetings, we have nobody out there, nobody.
We take turns sitting
I
around.
want to say that I can only speak for myself and my wife, but we deeply appreciate your service. We think what you do is the most important work that any citizen can do, and we do appreciate it. We were confused by what was happening, but we never assumed anything other than good faith. But we were confronted with a letter that raised those concerns. I hope I didn't imply that you're acting in bad faith. I certainly didn't mean to. I simply was trying to make the point that we were heading down a path of a conflict, a legal conflict, where we didn't want to go and we assumed you didn't want to go. So I thank you for your service.
So your point is well taken. Thank you all for coming. We can get things accomplished.
I have one more question.
Yes.
Can we just, so everybody's clear before we walk out of here, what is the next step? Tom and Allison are gonna work with Peter and the other gentleman to do the thing, then you're gonna get that, and that's gonna go back to the DES for permitting? Is that the next step, and then,
And this does not include Strong's Landing.
that's okay, I'm okay with that.
Okay.
I have no
I'm just
issue with
telling
that.
you, because that's separate.
No,
Part of Strong's Landing has a house in the middle.
yeah, I'm okay with that, I have no, I'm here to support everybody else.
Will go on before this construction happens, like we voted on.
Oh, you mean
Oh, yeah,
culvert
Yes,
fix?
the
Oh, that's
culvert fix
fine.
and all
Oh,
that.
yeah, that's not Lance, it's Strong's Landing.
Okay, I just want to welcome you all to Greenland.
Thank you.
Anything else?
Okay. If there is nothing else to come before this particular work session, a motion to adjourn.
So moved.
Second. Moved and seconded, all in favor?
I just want to tell you all, there's nothing but duck shacks and fishing houses up there. Yeah, absolutely.